let's just, because by the nature of our audience, when we say things like counsel, who is that person? What's his name? What do they do?
A counsel is a barrister, the person who would represent somebody's case in court.
Right.
We are solicitors. No. I can represent people in court, but it's not my specialism. The analogy that's usually given is a doctor, a GP, and a surgeon.
Right.
A GP knows medicine, or should do a bit, but it's a general practitioner. They might specialise in one or two elements. That's us. That's a solicitor. I wouldn't want to do some heart surgery if I was a GP.
Right, no,
Likewise, I wouldn't want to do a 5-day court hearing. That's why we go to a barrister or counsel. The barrister we've chosen is John Virgo, not the snooker player. He is 20 years experience dealing almost exclusively now in financial services claims. He'll be well known in the financial services industry, and importantly will be well known to the 4 defendants, potential defendants.
Right.
They will probably Google him, or they won't need to. They'll recognise his name and immediately recognise the fact that we have gone to a leading barrister in the financial services field.
Right. So we made a submission to council setting out what we believed to be the potential case against Arch, Capita, Boney Mellon and HSBC. Yes, those 4. And also we set out to council that we've already asked them to disclose and they've declined. And so the reason we're going to council now is we want him to say whether or not he feels we have sufficient grounds to go to court to force disclosure.
Correct,
yes.
John,
yep.
Correct. Because you would then bring an application to court broadly to the judge saying, we've asked for pre-action disclosure from these 4 people. They've said no. Can you please, judge, order these people to give pre-action disclosure? The judge will hear the arguments, it won't be that long, and he'll say, we hope, and counsel agrees, or barrister agrees, yes, I will make that order. You've classified the certain documents you want. It is not a fishing expedition.
Yep.
You've honed in on the class of documents that you want them to disclose. I am now making an order that you have to disclose those documents.
Right.
And then they will certainly do it.
Okay, now one of the things that council was concerned about, Alan, was the actual legal standing of the ACCG in respect of any application to the courts, because this now is going to move us on into the need for a new compensation group. Yes, so
yep.
I'll be redundant, but no worries there. And the ACCG will have to be set aside because of council's
yep.
view as to who has made the loss, who can actually be cited as a loss
right.
maker. So could you just explain what council have said there?
Well, council basically said the way it should work is this: the people that have actually suffered the direct losses due to the alleged mismanagement of these funds and the alleged breaches of regulatory duties are the investors. So any ultimate action to recover those losses would be by the investors.
So look at the ACCG structure at the minute.
Right.
The majority of its members are IFA firms who, whilst they have suffered financially, no doubt at all, by what's gone on, they have not made a loss at investment level.
That's right.
Only their clients have.
Yes. So council has said that the action has to be in the name of those clients. Similarly, the application for pre-action disclosure should be made in the names of the clients, the investors. Right. And so he said when we go back to the various parties and request that pre-action disclosure again, and if we bring an application, each individual investor client who suffered a loss and who is making that request or making that application must be named as part of that action.
Right.
Now, if there's going to be a lot of those, clearly it would be impractical and very difficult to take instructions from each one. So the structure he suggested going forward is that we have a special purpose vehicle, or SPV, a separate company set up that basically gives instructions on behalf of the investors who have chosen to be part of this action.
Right, so let's, words like special purpose vehicle,
right.
so everybody's aware, it's just another one of the ACCG.
Yeah. It's a bit like the ACCG, but it'll have to be a different company, a new one. Yes, it's just a company that set up to give instructions, and all the individual investors who choose to join in basically sign a document or a contract saying we give the SPV the right to give instructions on our behalf to our chosen solicitors.
It's fairly common in actions by multiple claimants. A alleging financial mismanagement or to bring
So
this
they all
sort of
gang
vehicle.
up and
Yeah.
basically do similar to what we've done with the ACCG.
Correct.
The only difference is council is saying no, it really has to be
That's right.
the frontline investor and
Correct.
nobody
Yeah.
else. Yes.
Yeah.
So from an IFA firm viewpoint, for this to move forward any further, they are going to have to go to their clients that are directly affected by what's happened with the CF Arch Crew fund ranges and say, you have to sign up to a special purpose vehicle on a named basis.
Yes.
Yes?
There's two things that the investors have to do, each and every investor. First, they have to enter into an individual retainer with Foot Anstey,
Right, yeah.
but then they also enter into a contract, very simple, with the SPV saying we basically give the SPV the right to give instructions to Foot Anstey on our behalf. That means that Foot Anstey, instead of receiving instructions from tens, hundreds of separate investors, get one set of instructions from the SPV, which makes it more practical to run on a day-to-day basis.
Okay, and therefore the board of the SPV, and David's very kindly put himself forward, and maybe another, because I don't want to do that role, okay, because of other personal issues rumbling in the background with crew and liquidators and stuff like that. So not sure how long I'll be here financially. So I don't want to enter into a relationship with a new SPV where I just bring it financial discredit because of things that are beyond my control, but I'm aware of are happening now. So that's where I stand, although I will obviously support the functioning of the SPV and provide information ongoing to it in terms of my assessment and analysis of what's gone on at investment fund level. Right. Okay, so we now have to say that after this broadcast, the ACCG's one last remaining thing is to basically pass the baton on to a new SPV, but that will only happen if investors believe it's in their interests to establish it and join it.
Correct, John.
Right.
Yeah.
Yeah. Okay. So we'll look at why why that might be a good idea in a minute. But also it means that we cannot actually go for pre-action disclosure without setting up the new compensation group.
That's right.
That's right.
And that's because who can be on the application?
Well, council has said basically that anyone who's part of the action group, any individual investor, has to be named on the application. Right. So some coordination needs to go on there to see who's interested.
In its simplest form, if I, David Turner, a private individual, sought pre-action disclosure, the four defendants would turn back and say, you, David Turner, have got nothing to do with this. You didn't invest anything. And I'd have to say yes. Yeah. If the IFAs did exactly the same, the four would come back and say, but you haven't lost any money. That's why we need the investors. Yeah. So the court can recognise, because they can say, actually, we have lost some money.
Right. So the next step, we can't do anything else legally. We cannot enter into civil proceedings without establishing the brand new compensation group, investor only. Yes?
That's right. Yes. Investor only compensation group.
Okay, I think we clarified that.
We should say the admin of this is not overly complicated and certainly not expensive.
Right.
It is, we have to do it because we have to go through that legal hoop. It should not take any time in particular, nor money.
Right, okay. Okay,
which is one reason why I'm perfectly happy for my name to go forward as one of the directors.
Right, right. Okay, we'll need to get onto some sort of assessment of fees and structures and so forth in a minute. But let's just stay on the legal path that we're currently treading. All right. So ACCG is coming to an end. New compensation group has to be formed. Once that compensation group is formed and it is adequately funded to at least carry us through to one, pre-action disclosure and request through the courts, and then secondly, to collate evidence to put back in front of council on an informed basis, because we will have had disclosure about what we really believe now the individual rule breaches actually are.
Correct. Yes? John, stage one is going to court. That's the legal stage in a way, going to court, getting them to disclose the documents.
Which gives us the information.
The information comes in. I'm not a financial advisor. Alan can have a look at a bit and see the regulatory breaches, but we need to go elsewhere and say, look, are our suspicions correct? Is there real mismanagement here? And we hope that person will then turn around and say yes.
Yeah.
And if that's the answer, then boy, we're in good shape.
Yes, because then what we do is we now produce another submission to council.
Yes.
But this is now based on going a lot further legally.
A lot further.
Could you just explain that next, if council says yes, go, what are we walking into?
Right, what you're walking into, or what an investor or an IFA is walking into, is really something quite big. The amounts at stake, I understand, are potentially very
the
large.
losses, I think, are probably going to come in about 180 million quid
Right.
of losses.
180 million pounds. Basically, what we're looking at is potentially suing 4 parties, 3 of which we know are good for the money, for 180 million pounds. I'm not saying it will get that high, but it could get that high. That means, what does that mean? A number of things. It means legal fees. It means experts' fees to look at the underlying documentation and work out quantum. It means barrister fees. It means court fees. It also means that you have an exposure to the other side's costs.
Yep.
If you bring on, the way English civil litigation works is if you bring a case and lose, you'll probably pay the other side's costs. We know they will have top firms of lawyers, so that will be expensive.
So are we it definitely sounds to me that the whole legal bill is going to run into millions, not hundreds of thousands, if you count the other side's costs as well.
If you count the other side's costs. Of course, I'm putting it in stages. Right. This is after we've got the documentation.
Yeah.
The exposure would come into millions. This would be one of the largest civil litigation actions in the country.
Right.